start. Good evening. I am Margaret Mickey Brum. Tonight I'm giving a presentation on trademarks and Native American tribes. Some of the information will be background information, some of it will be so fresh, it's fresh off the grill, and some of it will cause you to have additional questions. I appreciate you coming here, and I promise you, you will not be bored. Why should I listen to this presentation? That's my favorite picture of the puppy dog who says, yes, yes, I'm listening, I'm just resting my eyes, please continue your interesting story about whatever it was. Because I always assume that when I give a presentation, people are saying, why am I here? Why am I bothering? There's been a lot spoken about trademarks in the last year. A lot about names and places and what they mean and what they don't mean. This presentation shares some legal thinking and some facts to help the audience to a better understanding of facts rather than speculation. Okay? That's why you're here. You're not going to become lawyers. There's not a quiz, but there's a lot to be learned that is not presently known. What's a trademark? Trademark is any word, phrase, symbol, design, or combination that identifies your goods or services and distinguishes you from competitors. A trademark is used for goods, while a service mark is used for services. If I can find I always have a bottle of Coca-Cola with me. This is one of the most famous trademarks in the history of the world. Coca-Cola, the R in the circle, the type font, everything about a jar of Coca-Cola is part of the trademark for Coca-Cola. It's been enormously successful, and when people say Coke, in many parts of the world they simply mean a soda pop because it's taken over from all of the other brand names. So Coca-Cola is a trademark. Another trademark is for like a business or service. For example, if you happen to own a pharmacy and the name of the pharmacy was Campus Pharmacy, the name of your business as well as a trademark. It came from Campus Pharmacy. You'd have it on your bags, you'd have it on your invoices. It was a trademark of your business. It identifies the sources of the goods. In terms of use for goods, a service mark is used for services. I'm giving this program tonight under the auspices of the Marquette Sentinels Educational Services, of which I own that mark in Michigan. And the idea is that I'm providing an educational service for free. I forgot to say we won't be passing the hat, in case you were wondering later on about that. So that's the definition of a trademark. It's different than a patent, it's different than a copyright. They exist a long time. What's the origin? I put this in because somebody always asks me. First legislative act had to do with bread. In 1266, a king wanted all the bakers to mark their bread with a distinctive logo because there was competition among bread makers. And some of the more expensive breads had a more, you could sell it for more. So he insisted that each of the bread makers have a certain thing in their bread pan, and that started off. But there was always an idea that you would label things as a source of goods. First modern trademark laws were in France, and the first comprehensive trademark law to the world was passed in law in 1857. And we have our own trademark law in the United States, but we're not the only country. Trademarks have existed long before the United States was a country. Okay? What's trademark law in the United States? There's common law and state trademark registrations exist in all states. Federal trademark registrations came into being as of 1946 with the Lanham Act. Interesting enough, in the U.S. Constitution, in Article 1, Section 8, Clause 8, Congress shall for a limited time make available to authors and inventors the fruits of their labors. That is the basis for federal patent law and federal copyright law. But the Constitution did not mention trademark law. So it was always state-based, common law. And remember, at the time of the colonies became the U.S. states, there wasn't a lot of interstate commerce. So if you were making bread or making a plow in one state, usually your plow didn't go to other states. So there really wasn't any federal law. And when I started in trademark law last century, there were still clients who, instead of getting a federal registration, would get one in all 50 states. But the federal registration took over after 46 because you could file one trademark application and cover the entire United States. But it's harder to get a federal registration than it is a state, and they have tougher rules in terms of what has to be done. So it's always a judgment call. And there are international treaties where you start in one country and then you take your mark into other countries. It depends upon how valuable your mark is. For example, Campus pharmacy, if you were going to take it international, you would file what's called the Madrid Protocol. And that would keep your options open to file national in Canada, national in Mexico, national in whatever country that you were involved in. Okay? In the last 3 years, I worked for a company down in Houston. A boss called me one day and said, how come we don't have our #1 mark in the United Arab Emirates in Oman? And I said, because I wasn't doing your trademarks then. Well, we need trademark applications there right away. I said, okay. I think this was a Tuesday, and by Friday we had filed in United Arab Emirates and Oman because the business required the trademark be filed in those countries. So that's how the world is right now. It's very much global. Okay? Federal trademark registration, 1946 with the Lanham Act. That means you can have a federal registration. That trumps a state registration. But as you know, federal law preempts state law. How do you indicate that you consider a word, a symbol, or a logo your trademark? The trademark symbol TM superscript can be used for goods, and the service mark symbol SM can be used for services without registration. Many people think you can't use these symbols unless you have a registration, and the opposite is true. You can say anything is a TM if you consider it your trademark. For example, I'm sure you're big science fiction fans, and I'm sure you know about Captain Kirk and Mr. Spock and Dr. McCoy. Those character names cannot be trademarked in the federal system because the law doesn't let you get a trademark in a name, because there are actual military officers named Kirk that have a rank of captain, and you have to allow them to use their own name and rank. So what they do is they market those figures as Captain Kirk TM superscript and Mr. Spock TM superscript. And that was pretty cool to me that I figured that one out. But yes, the trademark symbol TM can be used for goods. Service mark symbol, my Marquette Sentinels Educational Services, is a service mark. Once the mark is registered with the U.S. federal government, the registered trademark symbol R in a circle can be used to indicate its status. For my class in business law, I bought a whole bunch of toys, and before I let the students open them and play with them, they had to go through the package and find out if it was a TM, R in a circle, or a SM. And then there's a whole bunch of packaging requirements if they're going to be sold in different countries. So yes, these, if you go home tonight and go through your medicine cabinet, you will see these symbols all throughout your medicine cabinet. Okay? Now, switching gears to the term Indian, which is kind of the subject of what we're talking about tonight. It's a misnomer given to indigenous peoples of North America by European explorers who erroneously thought they had landed in the East Indies. Now, I've read that the word Indian was given by Christopher Columbus, and some of his documents have been translated as Indios or Indian, and some of it had a different meaning altogether. The problem is he wrote in Spanish and then he wrote in Latin, and the translations were kind of iffy. So we've let it stand that Indian came from, they thought they had found the Indies. But of course the people who lived in the places where the explorers came from did not call themselves Indians. They had their own names for their tribes. Many of them focused on the phrase they meant the people there, the people here. But the word Indian came in a Western culture from the first travels to what became the West Indies. The use of the term Native Americans, which the government and others have adopted in the United States, is not common in Canada. In Canada, the term First Nation is more commonly used. So even in our continent, there isn't one word to describe indigenous people. There's Native American, there's First Nation, and then the farther north you go in Canada, there's another name for the tribes that live closer to the Arctic Circle. The term Native Americans refers more specifically to the indigenous peoples residing within the boundaries of the U.S. This is what it's like today. In 6 months, there may be another phrase that's more commonly acceptable. And this is because we've all lived through a time when different people had different names and they evolved into where we are now. For example, African American, which before that was black with a capital B, which before that could have been a small b, or the word colored, which is no longer used, no longer acceptable. But I happened to work for two people who were both from England, and one was very pale and he was an Englishman who came to the United States, and another one was very dark, and he came to England from Jamaica, and he was basically African English. So he had the most beautiful skin color and the most beautiful accent I've ever heard. But they were from the same part of the world, but they didn't have the same ethnic background. So it's important when somebody throws words around to get a flavor for what they're thinking. Because if you just type in Indian, you're going to get a lot of people from the Indian subcontinent, which has so many religions, so many faiths, and so many different tribes, and it's so much history of different explorers calling them by different names. Then you have the 1948 division between India and Pakistan and West Pakistan, and then it became Bangladesh as well. So the word Indian, I'm just trying to talk about it in this part of the world. There's other meanings in other parts of the world. National Congress of American Indians, NCAI, notice they say American Indians. There are over 574 federally recognized Indian nations, variously called tribes, nations, bands, pueblos, communities, and native villages in the United States. Approximately 229 of these ethnically, culturally, and linguistically diverse nations are located in Alaska. The other federally recognized tribes are located in 35 other states. This gives you an idea of the geographical origins of different tribes and bands. And one of the few things I was successful in getting through to my students, so many words are not in the Constitution, but the ability of Congress to regulate commerce among the states and amongst the various Indian nations is in the Constitution. They were recognized in the Constitution as separate Indian nations, which means they have a separate status. I also teach marijuana law, and federal marijuana law is different on Native American reservation land. So when I use the word Indian, I actually could have had 5 or 6 dozen slides. I decided to cut it back to what it means now. Typically in the US, we refer to it as Native American until someone says you should use another phrase. Does that make sense? Okay. Is the word Indian used in any registered trademarks? I looked under the USPTO's, US Patent and Trademark Office Federal Trademark Database, and I found 9,495 results for trademarks with the word Indian in them, and 13 results for Indian in a search of the State of Michigan Trademark Database. Many of the trademarks with the word Indian are logos using a chief's head. You remember a long time ago when TV used to end at the end of the day and you got a test pattern? Most of those test patterns had a Native American chief in the upper right-hand corner. And so these things have been around forever. But right now, in the US Patent and Trademark Office Federal Trademark Database, there's over 9,000 trademarks that use the word Indian or some variation of it. Therefore, what people have trouble with is they think if a word has fallen out of favor, that it no longer can be legally protected. And in the extent that you can't use certain words in trademark situations, I'll give you an example, we're all grown-ups here. If one of you were to come to this meeting tonight with a t-shirt that said F-U-C-K-U, that is an example of free speech, and therefore there's no turning that down. But if you were using F-U-C-K-U as a brand name for the t-shirt, that would not be registrable by the federal government because that would be considered obscene language. So there's a difference between your First Amendment rights to say something and what's registrable. Does that make sense? Okay. And I'm very happy that there's no one here with that word, but on the other hand, if you do see that, there's been a ton of court cases that talked about people have a right to use obscene language on their clothing. So the word Indian is not forbidden by the US Patent and Trademark Office. It's not forbidden by the state of Michigan if you use it as part of a name or as part of a designation. So conclusion, Indian is not a prohibited word to use as part of a trademark. That's just a conclusion. It doesn't mean you should or you shouldn't use it. It's not prohibited. Is the word redskin used as a trademark? 920 results for redskin in a search of the USPTO Federal Trademark Database. Nothing in Michigan for redskin. However, redskin is not a prohibited word to use as part of a trademark. Now, it is true that the Washington Redskins changed their name to the Washington Commanders, and it is true that when they went up for renewal of their Washington Redskin trademark, it was denied and it was up on appeal. But what happened there was not the trademark issue. Two of their major sponsors, one was the owner of the stadium and one was a major sponsor, told the team that they would drop their sponsorship unless they changed the name. And that's why they changed the name. Now, I don't know how many of you are aware of this, but right now, even though the name of the team is legally the Washington Commanders, there is a massive federal lawsuit filed by the heirs to the Native American who was the model for the Native American chief that appeared on the Redskins helmet. He was a real person, in other words. They could trace it back to a real person, and his family has sued for returning his image to the helmets because they considered it a badge of honor. So when people say it's illegal or they dropped it because it's not a good trademark, I always hesitate to agree with something so glibly because it's usually more complicated than that. And that lawsuit is nowhere near settling. In fact, there's 3 or 4 Facebook groups you can join, Washington Redskins Forever, and events go on, and there's as many fans of that logo as there has been. So this is the word Redskin, which I've heard a lot about, saying it's obscene, you can't use it, you shouldn't use it. And I'm just here to tell you that the United States Patent and Trademark Office has not universally canceled all the registrations with that word in it. That hasn't happened. Individual registrations have been challenged, but not the entire word. Is the word Redmond used as a trademark? There's 561 results for Redmond in a search of the USPTO Federal Trademark Database. 1 result for Redmond in a search of the state of Michigan trademark database. That's a trademark I own. The Marquette Redmond trademark, I own it in the state of Michigan. That's because when our local school decided to drop it, they affirmatively said they weren't going to use it anymore. It's called abandonment. Usually when you change a mark, you keep the rights in it by saying, we're going to use the new mark, but we're not going to give up our rights in the old mark. But they went on every page of every news story out there, we've abandoned it, we stripped the school of it, we're not going to use it anymore. So that's called an affirmative abandonment. You have to wait a year because you have a year to change your mind. But after I waited a year and they hadn't taken it back, I filed in Michigan for it, and it's been granted for me. I own it on clothing, which is why if you go out to Martin Sports in Westwood Mall, you can see the Marquette Redmond t-shirt there. Okay? So yeah, you don't have, just because you change a name doesn't mean you have to abandon your old name. The MAPS district had rights, common law rights in that name that would have continued even if it wasn't their #1 trademark, but they affirmatively said, nope, we're not going to use it anymore. So I took it, legally. I didn't steal it, I took it, okay? Redmond is not a prohibited word to use as part of a trademark. Hard for people to understand because there's been a lot of words taken that if you can't use that, if you use that word at all, it's an obscene word, and that's not how it's viewed legally. There's other, I mean, my friend Kathy and I both remember a teacher in 8th grade named Mrs. Redmond. And if you look up the word Redmond online, there's at least 300 family last names with the word Redmond. So there was some talk about making it an obscene word and then using asterisks in place of the vowels so that you could not actually say it, but that's not the way it's presented. It doesn't have to be presented that way. It's a name. So that's the status of the word Redmond. Until MAPS expressly abandoned the use of the Marquette Redmond mark, MAPS owned the trademark under common law. They never registered it, they didn't have to. But with 60, 80 years of use, they had the ownership rights, which meant if somebody else manufactured Marquette Redmond gear like jerseys or hats or chucks or anything, they could stop them because they owned the trademark. It was a piece of intellectual property that was part of the assets of the school district. I don't know if people understand that a trademark is considered an asset, just like all the trucks the school owns, or all the buses, or all the desks the school owns. But when you expressly abandon it, you basically throw it away. So they threw it away. After maps expressly abandoned the mark and 1 year had passed, a third party, me, could and did legally file a trademark application for the use of Marquette Redmond on clothing, which application was granted, making me the owner of the Marquette Redmond trademark in the state of Michigan. If they hadn't expressly abandoned the mark, they still could have profited from licensing the use of the mark on clothing. So I wanted people to understand that you can decide to change a name, but there's value in the old name. Most of us have had, there's websites where you can buy vintage jerseys. You can buy the Marquette Iron Rangers jersey from hockey websites, even though that team hasn't been on the ice in 30 years. So there's value in these old names, but not if you expressly abandon it. And so this is something I wanted people to be aware of, that something was done that didn't have to be done. And then during the recall discussions of last summer, I was told by more than one person that they understood that the school had forbidden teachers to use the phrase Marquette Redmond and had forbidden students to come to school wearing Marquette Redmond shirts. So when I got the trademark, I went to Martin Sports in Westwood Mall and had a whole bunch of t-shirts made up and told the students of Marquette High, all they had to do to get a free Marquette Redmond shirt was come there with their student ID and they'd get a free one. And that, as far as I was concerned, anybody could use the phrase Marquette Redmond. So we haven't had any issues with kids being sent home for wearing Marquette Redmond or people getting into fights over it, okay? So it's just as simple as that. Now, had they kept the trademark, they could have stopped people from using it, but they chose not to keep it. Secondary meaning. This is a really important concept when it comes to picking apart a word and deciding that you can't use it anymore because people are concerned about its use. Secondary meaning acknowledges that words with a regular and distinctive meaning their own could become synonymous with a specific product. The general public then specifically identifies a product by this secondary meaning. That's a lot of legal stuff, but courts look at 4 factors: the length of time and how the mark has been used. Marquette Redmond has been the name of the athletic teams at Marquette since the 1930s, so it's almost 100 years. How much advertising and promotional work has been done for the owner's business? Every year, Marquette Redmond jerseys, Marquette Redmond stories, every year they used it. What efforts the mark's owners have been made to create a conscious connection between the mark and the owner in the mind of the consumer. I was up in Negaunee this summer at a parade, and a gentleman recognized me and said, "How's the fight with the school board coming?" And I said, "Well, it's coming along." He said, "Well, I just want you to know I'm not from Marquette, but I really hope you win, because I was talking to my wife and she and I agreed it's always been the Negaunee Miners versus the Marquette Redmen." I said, "You're right, it's always been Negaunee Miners, Miners being the team from Negaunee, versus the Redmen being the team from Marquette," which is they didn't consider Miner as a separate word from Negaunee, and they didn't consider Redmond as a separate word from Marquette. It meant the team from Marquette. And I thought that was the best definition of secondary meaning I could give you, because to him it was as clear as a bell. Marquette Redmond meant the team from Marquette, and I thought that was something worth sharing. The mark's owners have made to create a conscious connection. Marquette Redmond was all over the place until a year and a half ago when they changed it. The extent that the public identifies the name with the mark's services or goods. I don't think anybody in the Upper Peninsula didn't know that the Redmen were the team from Marquette. I mean, there simply wasn't any confusion about that. For 90 years, that is what people had said and used. So Marquette Redmond has acquired the secondary meaning of meaning only the athletic teams from Marquette Senior High School. That's my legal opinion, and I will stand by that, simply based on what people have said to me. The splitting of the hairs that I've heard about people saying you can't use the word Redmond, it's insulting. If you use it by itself without connection with 90 years of history, there might be an argument for that. But if it's used in connection with a high school where it's been used for 90 years, and where the school, when it switched from Graverette to Marquette Senior High School in '65, the students then were offered the choice of keeping the name or changing the name, and they voted to be the Redmen at Marquette Senior High School. So there was a continuity. There was never a break in the line of continuity. And I think that's important for people to note as well. Is the word sentinel used as a trademark? Yes, it is. 4,540 results for sentinels in the search of the USPTO database. 4 results for Marquette sentinels in the state of Michigan trademark database. Conclusion, sentinels is not a prohibited word to use as part of a federal trademark. It's not. There's a bit more about that word though. What's the status of the federal trademark applications for the use of Marquette sentinels on clothing? I filed mine first, and then the MAPS attorney filed theirs. Both of us have received rejections of our trademark applications from the federal government based on prior applicants who have used the word sentinels on clothing. In other words, because other people have used the word sentinels before us, neither one of us is going to get a separate trademark registration for Marquette sentinels on clothing, which means when the new name was picked, the name was picked that was not registrable. In other words, it was not novel enough, it wasn't new enough to be registered in its own name. And that's something that when you change your name, you want to have a name that's protectable because there's value in a name. And I spoke to their attorney 2-3 weeks ago. We both have, it's public knowledge, we both have the same office action. And I said, well, I was just gonna let mine go quietly abandoned because I don't see there's any way around it. I said, what are you gonna do with yours? And he said, well, yeah, I'm gonna rely on common law and other protection. And we both realized that they picked a name that wasn't protectable. And you're saying to yourself, but I don't understand what that matters. Well, do you remember a few years ago when people were enamored of the Waters Meat Nimrods? Do you remember that was all over the news? And it was so cool, and the big city news people came up and said it's such an unusual name. And my nephew educated me, it goes back to the Bible, and it was the only name like that in the United States. I remember they interviewed the principal about 2 months later, and he said, you know, the best part about this is we made over $14,000 in merchandise sales we never would have made without this. There's value in the name. And if it's protectable, so you're the only source of it, you can make more value. And so when you change your name, part of the changing process is to have someone look at your proposed name and give you an opinion as whether it's protectable or not. I wasn't asked, I just went ahead and filed mine. I did not ask the other attorney because it's none of my business. I'm just saying is it looks like it's not going to be protectable for clothing, which is the jerseys, the socks, whatever, you know, whatever the guys and gals wear. That's where it's mostly seen. So it's been rejected. Therefore, the preliminary conclusion is that MAPS Board of Education selected a nickname for MSHS that was not protectable when used on clothing. That means other parties besides MSHS can use the Sentinels mark without paying royalties to MSHS. In other words, they can make up their own jerseys and sell them as Marquette Sentinels jerseys and not have to pay a royalty or pay the price that you would get a jersey from, you know, the Marquette Sentinels store. There's a store online. And then the owners of the current Sentinels trademark registrations, if they were upset enough about it, have the option of demanding that MSHS stop the use of the Marquette Sentinels mark on clothing. And they would only do this if it somehow cut into their own business, but they have the right to do it because they have prior registrations. That's another reason why you don't want to change your name casually. You want to know what you're walking into. It's called freedom to operate. And you want to have a name that's protectable and that no one else can stop you from using. In this particular case, Sentinels doesn't appear to be protectable under federal law, and it appears to be vulnerable if somebody decides to try and stop us. Okay? Now, nobody knows this. This is just in the last 2.5 weeks. And like I said, I'm not telling you any secrets. This is publicly available information. Now, this is something that no one knows, but everybody will at the end of the night. The reason the name was changed was ostensibly because it was offensive to Native Americans. That was what was hammered into us. And if you disagreed with that, you were called a racist. Interestingly enough, I did additional research and found, is there a history of the word sentinel being used in connection with Native Americans? And yes, there is. How many of you know about Marquette University in Milwaukee? Yes. Marquette University is named after Jacques Marquette, as the city of Marquette is named Jacques Marquette was a Jesuit missionary, so it's a Catholic university. Well, as a Catholic university, it has a library, and in the archives of the Marquette University, they have from 1902 to 1962 a magazine called the Indian Sentinel. Okay? Now, you would think to yourself, well, the word Indian Sentinel, it must be a positive connection. And the answer to that is no, it is not a positive connection. The name Indian Sentinel was the name given by the Catholic Church to a magazine they published on a regular basis over the year to ask for funds from Catholics all over the Upper Peninsula to support the Indian boarding schools. In other words, the most colorful connection of the word Indian Sentinel is with a magazine designed to raise money to run boarding schools, which I have not seen or heard anyone say anything positive about. The boarding schools were set up by the government, of the federal government and the state government. And some of them were day schools and some of them were boarding schools. But in many, 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 many instances, the families of the children were given no choice. People came to their homes and took their children from them, and when they got them back at the next holiday, they couldn't speak their native language, they only spoke English, they only responded to their English name, and they had been taught to accept only one culture's way of thinking about the world instead of embracing their original family culture way of thinking about it. There's just not one positive thing written about the Indian boarding schools. And yet the Marquette Board of Education picked a name that is associated with fundraising for the Indian boarding schools, which could have and should have been avoided. Because when you rebrand to avoid a problem, you don't want to pick another name that makes the problem arguably much worse. Because whatever you want to say about Redmond, it has secondary meaning, but Sentinels in this case, like I said, there's just nothing positive about the boarding schools. And this was brought to my attention, and I reached out to the archivist at the Marquette University, and I got the whole history of the Indian Sentinel magazine, and that was the name, and I got several copies, and it was used to describe young people who go to these schools and what they were accomplishing, and the whole idea is how positive it was. But if you know that they have a day once a year now to a memorial for the students who never returned from those boarding schools. You know, up in Canada, they found graveyards with unmarked graves. So again, when I say there's nothing positive about the boarding school connotation, there's nothing positive about it. And this to me is an error that absolutely is unforgivable. It just is. So why did MAPS pick as a nickname a word associated with the Indian boarding schools? I have no idea. They never described where they got their names from. They never described why they picked the names they did. They never answered questions about the names. They just picked the name. Now, before Marquette Indian Sentinels in the boarding schools, there was the Marquette Sentinels, a hockey team my grandfather managed and my uncle played on. That hockey team dissolved in the late 50s. That was a positive connotation in the sense that they brought the Red Wings up here. It was a big deal. But again, no connection between that and Native Americans. But the Indian Sentinel magazine was nothing more than fundraising to continue the boarding schools. Arguably, replacing the word Redmond with the word Sentinel showed ignorance of the MAPS Board of Education relative to the negative history of the Native American community and the boarding schools. And that was the point I wanted to make here, which is, I believe that the decision to change the name needs to be revisited, the original name needs to be restored, and we can talk about the cost of rebranding, which is extensive, and money has to be put aside for rebranding because just this past week there was a story in the news about how many different school districts, including Gladstone, had received grants from a fund set up to aid school districts in changing their names away from historical Native American names. Of all the schools listed, Marquette Senior High School wasn't on that list. Again, I don't know why. We're in the midst of rebranding. It would seem that we would be a candidate for these types of grants. But what has not been adequately described, we couldn't get any information from the school board about how much it would cost to do the rebranding. So I wrote to a school in Saskatchewan, which was listed in Wikipedia as having rebranded from Redmond to something else. And as I said previously, they gave me a list, and their rebranding process took several years and cost $500,000. And I don't believe the Marquette Board of Education has had that discussion with the people about how much the actual rebranding is going to cost and who's going to pay for it. The idea originally, they were told, the people were told that we would get a grant from the Sioux tribe, and $30,000 was promised. However, after the name was removed and before any money could be transferred, it came out that the person they were talking to at the Sioux tribe did not have authority to use Sioux money to rebrand the Marquette High School. So no money was ever transferred from the Sioux tribe. So again, part of what I wanted to talk about tonight, and I appreciate your thoughtfulness and your patience, is it's not as simple as saying you can't use that word, it's obscene, because that's not true. It's not as simple as saying, well, we switched to Sentinels because that's a better word than Redmond. That's not true. And the third thing is, well, it's no big deal to rebrand, we'll just filter it in. We would have made those changes anyway. And if you talk to a school that's actually done it, it's hundreds of thousands of dollars. And this is what I think is missing from the dialogue about this, and which is why I gave the speech tonight, is to give people more facts to work with. Because I've learned in the last 10 months, if you go before the school board and object to the change, you're very quickly labeled racist. And I don't think you're racist when you point out that the name they picked has a far worse connotation than the name they gave up. And the statement that it's not going to be a big deal, it's not going to cost a lot of money, simply isn't true. So that is in conclusion. And if Kathy would shut off the camera, I'll be happy to answer any questions you ask, just because I want you to feel comfortable.